welcome to Bloomberg Quint. You're watching Insolvency Diaries. RIAs can take over SR Steel. Singles can bid for Bhushan Power and Steel. And Manoj Gaur should get an opportunity to submit a resolution plan for JP Infra. But doesn't the Insolvency Code bar all defaulting promoters to bid for their companies? The Mumbai NCLT doesn't think so, and its recent ruling has turned the intent of Section 29A on its head. Section 29A was notified via an ordinance in November last year and lays down that errant or defaulting promoters cannot be resolution applicants. But before we get into the far-reaching implications of this ruling, here's Vishwanath Nair with the backstory.
Thank you so much for that, Payaswini. And this is a rather interesting case where Section 29A has been supposedly turned on its head, and possibly we could see some of the promoters who were barred under Section 29A make a comeback. Now let's understand what this case exactly is, and this case refers to an insolvency petition that was filed against WIG Associates. The case was admitted under the insolvency and bankruptcy process in August 2017 at the Mumbai bench of the NCLT. Following this admission, the resolution professional who was appointed in this case called for plans. But what happened at the end of this entire process by April 2018 was that Mahinder Vig, the promoter of the company, was the only person who submitted the resolution plan. Now, how did we get here? Well, Mahinder Vig went to Bank of Baroda, the only creditor on the COC, and suggested a one-time settlement plea. Bank of Baroda said that it is agreeing to accept this one-time settlement plea if it has been brought under the insolvency and bankruptcy process. So Bank of Baroda went to the resolution professional and suggested that this resolution plan be brought under the insolvency and bankruptcy process. After that, a question was raised on whether the promoter of a company can actually submit a resolution plan, considering the government had introduced an amendment barring promoters from doing so. So the NCLT in its order says that the COC should consider the plan that has been submitted by the promoter. It also says that the rules of the game cannot be changed in the middle of the process. Essentially, the case was admitted back in August 2017, and the amendment came in November 2017. So what the NCLT says is that in the middle of the whole process, you can't just suddenly change the rules of the game. As part of its order, the NCLT also ordered Mahinder Vig to clear any sales tax dues, even if the sales tax department did not submit any claims in this matter. In its order, it also mentioned some very important points, and some of these important points include this: that amendments which affect the legal rights of an individual must be prospective and cannot be retrospective in nature. In this order, what the NCLT is also saying is that rights of a party in an appeal are determined under the law in force on the date of the suit. So as of when the suit or the insolvency application was filed, that was back in August 2017, the rules that were applicable then can only be applied across the entire insolvency resolution process. Remember that it was on the 23rd of November in 2017 when Section 29A came into effect. So essentially, the NCLT's Mumbai bench has said that this cannot be applied to any case that was admitted prior to this November 23rd date. And that is important because the 12 large cases which we have been discussing over the last 1 year or so have mostly been admitted prior to this date. And therefore, how this amendment is expressly understood by the NCLT and interpreted by the NCLT holds a lot of bearing on how exactly resolution is effected in these cases. Back to you, Payaswini.
To understand how this ruling will impact cases that were admitted for insolvency prior to the November ordinance, I'm joined by Vikram Nankani, senior advocate practicing at the Bombay High Court. Mr. Nankani, thank you for joining us here on Insolvency Diaries. Mr. Nankani, the crux of this ruling seems to be that since WIG Associates was admitted for insolvency prior to Section 29A coming into force, the right of the promoter to submit a resolution plan cannot be denied. Do you see any merit in this reasoning of the Mumbai NCLT?
I have no quarrel with the legal proposition that an amendment cannot take away a vested right. The question is this principle of law applicable in this case? We are talking about two persons here. One is the corporate debtor and the other is the resolution applicant. The disqualification which was introduced on the 23rd of November 2017, or with effect from 23rd of November 2017, was on the resolution applicant and not on the corporate debtor. Now, if you look at the principle of not taking away vested right, it will be seen that when the company petition here was admitted, the corporate debtors application was admitted under the IBC, there it was admitted on the 24th of August, and that was qua the corporate debtor. The disqualification which has been introduced and which was the subject matter of this case was a disqualification qua the resolution applicant. What was the position or the status of the application made by the resolution applicant who was admittedly disqualified under 29A? That is an admitted position. As of 23rd of November 2017, if we go by the order, it says that he had made an application on 30th of October 2017 to the resolution professional, which in turn has to be approved by the credit committee of creditors, and therefore when that law came in, he only had an application in place. In fact, the order further records that on 14th of December, a second application was made by the same resolution applicant. So therefore, the question is, was there a vested right already in Mr. Wig when he made the application? To my mind, it was only an application pending, and that does not give rise to a vested right. A person who has made an application has only a right of being considered, and that's about it. Whereas the principle of vested right stands on a different footing, where a person has altered his position in a manner that today, if the law comes in and hits him hard retrospectively, then he would be prejudiced because he is not in a position to alter his stand or position. That, I don't know, is something which seems to have been not brought to the attention of the tribunal. Probably proper assistance was not rendered to the tribunal. So the moot point which will arise is that, does any vested right of the resolution applicant get affected by virtue of the introduction of section 29A? And if on that day there was no right which was already vested in the resolution applicant, the question of it being taken away does not arise. In fact, as the facts stated in the order of the NCLT, it seems that everything happened post thereafter. It seems that the committee of creditors approved it in March of 2018. There was an publication in the newspapers in April of 2018, and finally when the application was made to NCLT for approval of the resolution plan, it was again sometime in April of 2018. So everything which is required for the resolution plan to be finally approved by the NCLT as the adjudicating authority happened post 23rd of November 2017. So I think while this order has raised interesting issues, it has misapplied, in my respectful submission, the principle of taking away vested rights.
Isn't that vested right, wasn't that vested right, sir, in fact was taken away? Because when this application was, admitted by the NCLT, and if I were the promoter, I, as per the law at that time, thought that I have the right to bid for the company and, become a resolution applicant. But that changed, that position or that right changed as soon as this ordinance was notified. So can you explain to me that why would you not say that that right vested in this individual or the promoters?
To my mind, the corporate debtor who makes an application under section 10, or even if it's a case of a financial creditor who has made the application under section 7, it doesn't matter who makes the application for insolvency. If it is admitted and the provisions of section 13 and 14 kick in, then the question is that the company or the RP on behalf of the company can put in place, with the approval of the committee of creditors, a plan to revive the company or to ensure that it is restructured and not put into winding up or liquidation, which is the consequence of the resolution plan not being approved. So what the company, it doesn't have in that sense a vested right. It gets an opportunity of trying to revive. Now, revival is done through various means and mechanisms. and it is therefore the scope is wide enough for the resolution mechanism to be brought in before the resolution professional by any person. Now, any person, if you take away a certain class of persons from them, and if that classification is based on an intelligible differentia, then unless you challenge that classification and you challenge that, saying that section 29A has reduced the scope of or the class of persons who would now be eligible to come forward with a resolution plan, unless you challenge that section 29A, if the section stands by itself, then the question is, at the time when the resolution plan is being considered, first by the resolution professional and then by the committee of creditors and finally by the adjudicating authority, does anyone had a vested right prior to that? I can understand if the committee of creditors had already approved, and I would maybe I would walk that extra mile in favor of the resolution applicant. Had the committee of creditors approved the plan submitted, and it may be awaiting a formal adjudication or approval from the adjudicating authority, maybe one could say that now that everything has been fallen into place and the consequences on the corporate debtor of this not being approved are drastic, in the sense that then there may be no further resolution plan available and it would go into liquidation. But when you are examining the principle of vested right, it is in this case, since the disqualification is in relation to the resolution applicant, the question is, the person who is disqualified, does he have a vested right, and has he lost the vested right? In case of corporate debtor, it doesn't restrict anybody else from coming in. There is a whole lot of universe of potential applicants who could make the resolution application, and therefore, if for some good reason, and as I said, subject to constitutional challenge, if the Parliament has come up with a condition that certain classes will be excluded from the zone of consideration, then to my mind, that is not taking away a vested right of the corporate debtor, is a strong argument in against the corporate debtor.
Okay, so the fact that the court does give these errant promoters or defaulting promoters 30 days to cure their ineligibility and then become eligible to bid for their companies and apply as resolution applicants, can that be an argument against the reasoning of the court that your vested right isn't going away? We are asking you still have that vested right, but as long as you cure your ineligibility.
So again, we come back to the question of then satisfying the criteria laid down in section 29A. So which is again a strong argument in favor of those who want to apply section 29A to pending applications also, that you're not permanently disqualifying somebody or not perpetually disbarring somebody from applying. There is a caveat to it, and there is a rider is subject to satisfying that condition, you are eligible. So that's again a strong point in favor of those who want to rigorously apply section 29A to all pending applications.
The other thing that Mr. Nankani, I found a little curious in this order was that section 34 of the IBC that expressly states that the creditors committee cannot approve a resolution plan that was submitted before the ordinance if the resolution applicant is ineligible as per section 29A. This does not find any mention in the court's ruling. Did you find that curious too?
You're very right, and therefore, as I said earlier, that perhaps proper assistance was not rendered to the court. Maybe in the facts of the case, on a substantial basis, one would have thought that this is a small company and it requires to be revived, and there is nobody else coming forward despite the advertisement, and only one person came up with a resolution plan, and the rest of them did not express any interest. So maybe in the facts of the case, that is what weighed with the tribunal. But all said and done, you're absolutely right. Section 34 is a clear pointer to the fact that there is a bar in the lenders also considering such an application which is pending as on the date the ordinance or the Amendment Act came into force, which again militates against the principle of there being a vested right.
If I were to argue from the court's point of view, they've relied on the Supreme Court ruling in Videocon International, which had held that pending proceedings are to continue as if the unamended provision is still in force. So even if one were to argue that the court specifies that the plans that have been submitted by ineligible applicants must be revisited, is there some merit in challenging this provision because it takes away a substantive right that existed when the company went into insolvency?
You used a very important expression, substantive right, and I think that is the key question. As I mentioned earlier, there is no quarrel with the legal proposition. As a proposition of law, that a parliamentary act or any amendment to an act cannot take away a vested right, there is no dispute on that. That's a settled law. Question is it taking away a substantive right? You mentioned about Videocon's judgment. That's a case which deals with penal consequences, penal action. This is, as I said, when you make an application, you only have a right of being considered. It's still the committee of creditors, for good reasons, may not accept your application and they may reject your proposal. And if they don't approve it, then it doesn't go to the next level. So your only right is a right of being considered. And of course, if they reject it, you have an audience and a remedy before the court, and the court will then look at it. In fact, this very order says that that consideration should be an objective consideration and not a subjective consideration. So you have a right of consideration. The question is the right of consideration a substantive right? And that's about it. And there the courts have held in many other different contexts that where a mere application is pending, application does not give rise to a substantive right.
Okay, let me come to the final question then, and that is the crux of this ruling. What do you think will happen as a result of this ruling? Will this encourage promoters whose companies were admitted into insolvency before the November ordinance to put up a fight against Section 29A?
I suppose as long as this order stays and holds the field, I'm sure there will be people who would like to take advantage of this order. So unless this order is altered by a judicial process, I'm sure that people would like to take use or make use of it or take advantage.
So ongoing proceedings where, let's say, the big 12 cases, they are at different stages of the resolution process. In some, the bids have been accepted. In some, the bids are being litigated. The eligibility is being litigated. Would the fact that this probably can give more ammunition to errant promoters, do you think will then lead to extended timelines in these cases?
I'm sure it will add to the number of issues already involved, and the list of vexed issues will only increase with this order. So I'm sure that this will have to be tested out again in some other forum and in some other proceedings. Please remember, this is an order of the learned single judge or member of the NCLT, and therefore that is also an aspect which will pan out when this order is cited. If it's affirmed by another bench, then of course different considerations will apply, but it's an interesting stage.
Okay, and one which gives ground to defaulting promoters who have used even the slightest bit of vagueness in the process to go to the courts. Mr. Nankani, thank you so much for joining us with your views on Insolvency Diaries, and thank you so much for watching. We'll see you next week.